acknowledgement of country. And I know that people are all over the place. So, you know, for example, I know that Julie is in Ipswich, is that right? And so I'll just read the standard one that's provided by from the university. We acknowledge and honor, and apologies if I get the pronunciation incorrect. We acknowledge and honor the Jayabel and Jaware peoples of Toowoomba, the Jagera, Yugara, and Ugarapul peoples of Springfield and Ipswich, the Gadigal people of Eora Nation, Sydney, and the Camboal peoples of Stanthorpe as the traditional owners of the lands and waterways where the University of Southern Queensland is located. Further, we acknowledge the cultural diversity of the Aboriginal and Torres Strait Islander peoples and pay respect to elders past, present, and future. We celebrate the continuous living cultures of First Australians and acknowledge the important role played by Aboriginal and Torres Strait Islander peoples in Australian society. The university respects and acknowledges our Aboriginal and Torres Strait Islander students, staff, elders, and visitors who come from many nations across Australia. Okay, so hello, Nick. What I'd also like to do is just briefly go through some introductions. We have Mr. Nic Gould, who's the Associate Director of MCR Defense and a graduate of USQ. And luckily for us, he's taken the construction law course. We also have Mrs. Julie Copley, and she is the lecturer for construction law elective, as well as many may know her from property and trust B course. And she has also a wealth of experience, not only with the on the academia side, but also with the Queensland government side and also industry. And just a brief introduction of myself. My name is Matthew Endo. I'm a second year law student in the JD program at USQ and the organizer of this seminar. And I'd also like to give special thanks to the USQ Law Society for promoting the seminar on various social forums. So it looks like Nick is frozen. So if you wouldn't mind, can I pass it over to you, Julie, to just kind of give an overview of what the construction law course is all about?
Thank you, Matthew. Thank you for the introduction, and hello, everyone. I can see that some of you from your names are enrolled already in S1 in 2021, but in addition to any material that you might have read or that other students who aren't yet enrolled or may be thinking about construction law for the future might have read, I thought I'd speak briefly, as Matthew has invited me to, about the particular construction law program at USQ. We've been running it for about 5 years now, and the genesis of construction law at USQ was actually a cross-disciplinary one. And I think that's an important thing for law students to appreciate, because it's one of your few opportunities where you will have a cross-disciplinary cohort in the classroom, which is actually a great thing to be able to put on your CV to say that you have experience working with people in other disciplines and that you've done that productively. But it also has driven the design of the course itself as well. So it's very practical, it's employability focused, as I'll explain to you. Construction law can be defined. It's actually very difficult to define it because it's such a nebulous concept, and people practice in all sorts of areas that they might put a construction law title on. But construction law can be defined as the commercialisation of property interests. Usually they're private, but not necessarily. And usually the property interests are in relation to land, but not exclusively. So, for example, historically, the construction of boats and ships has been, or large ships, has been regarded as falling within construction law. That definition, though, gives us a sense of two different aspects. So one is that you have property interests, particularly where that's in their interest in land. They're granted by your state or your jurisdiction on particular terms, and with the understanding that you are being granted that interest to utilise it for your own purposes, but within a broader community. So we can't ignore our neighbours, we can't ignore our broader community. And the second aspect of that is that we also, when we commercialise something, we think that we're free to enter into contracts and do all sorts of things, and that it's actually a one-on-one or a business-on-business relationship as well. So for the law that is construction law, I think there are two important implications from that. One is that we have legislation that regulates just about every aspect of construction law, and that changes regularly. But also the case law about that is handed down regularly. And so we have security of payments, which is a large part of the legislation and the case law that we looked at. How to ensure that cash flow, which is the lifeblood of construction, can actually continue to occur. How do we keep people safe? We've been talking here in another meeting today about Lex Salus, and Cicero said that the highest law is the safety and well-being of people. And I think that's particularly relevant in construction projects. So we have workplace health and safety legislation. We have legislation like corporations law that regulate business arrangements. So the second aspect of construction law then is that those private commercial arrangements that you might enter into so that you can exploit your property interests, whatever in whatever form they exist. So for students, there's an awful lot of law, and there is an expectation that you will have an appetite for that breadth and depth of law that construction law will demand of you, in addition to learning about the practicalities of construction. So, you know, as we all know, if you're building something, if you're building on land, you don't know what's below the land, and that's, you know, those latent defects or latent problems that you might come across are just one example of the way in which there are practicalities that construction law students need to get their head around, but also about the terminology and what that means for the law as well. So the next point I wanted to make is that because of that huge body of law that construction law can draw within it, there are, again, two implications for students. So one is that hopefully if you're enrolling in construction law, you're going to feel comfortable with all of that. That you feel that you know enough about contract law, that you have enough, that you're happy to read legislation for understanding. If you find legislation, find case law, think about the breadth and depth of law without feeling challenged, unduly challenged by it, because really what you're doing in each case for every student is you're getting from construction law what it is that you need. So you don't need to read all of the law, but you need to have a sense of what law it is that you really do want to pursue. And I guess that leads us to the, I was just going to say, in that context, where across the law program at the moment, revising our learning objectives to ensure that they align with the expectations that the professions have of us, to ensure that we produce graduates who are able to do the things the profession wants, but also that we have used the right sort of language. So you can go into along to interviews and you can immediately say, yes, I understand about reflective practices, for example, and this is what I've done in my degree. I can demonstrate that I have the capabilities that you're looking for in this role. So we're redrafting our learning objectives to make sure that they're aligned with the admission rules and also our threshold learning outcomes. And so what that does is it indicates in construction law that you've got a degree of competency that usually is towards the end of your degree, because we're expecting that you are happy with contracts, and then you can apply that knowledge of contract law to construction contracts. So it's more of an applied law that you will be drawing on in relation to construction law. Secondly, the assessment is also directed to students who are towards the end of their degree. So you will have opportunities to produce legal research writing that you might then exploit to get a job or in the job that you're in. We use client-focused problem solving, so we get you to advise clients by way of problem solving, and as I just mentioned, reflective practice assumes that you will be able to operate in a workplace with a degree of thought about experiences that you've had, so that you can then develop your thinking about it and you will respond better the next time. The other implication for students is that there are lots of opportunities from this course. So in relation to the Society of Construction Law, there will be free memberships available for a proportion of you. I'm going to talk about that further in week 1 and 2, because we'll work that out around the census date, so we don't have people who enrol just to get that membership and then go off and do something else. But similarly, just as in family law, there's a $1,000 prize for the student who achieves the highest mark. We're introducing that courtesy of the Society of Construction Law this year. But they actually want to build relationships with construction law graduates from USQ. They've chosen our university ahead of others in Queensland who offer construction law because of the fantastic program that we have in Melbourne, because of the alumni that we have who are such a good advertisement for our law school and the construction law course. There will also be lots of opportunities for engagement with the profession. I've put one of those on the study forum already, so there will be more of those to come. But as I mentioned, there'll also be opportunities to engage with alumni. And you have one of those that's coming up now, so I won't take any more of your time. Happy to answer questions down the track. Thank you, Matt.
Thank you very much, Julie. And speaking of esteemed alumni, Mr. Nic Gould, we understand that you are a USQ former student and also have done the construction law course. So would you mind telling us about your life as a construction law lawyer?
Sure, thank you. Is that coming through okay? I'm having some bandwidth issues. I'm actually on the client site at the moment, so I've sort of hidden myself in a meeting room, so hopefully that's coming through okay. Thanks, Matthew. Thanks, Julie. Yeah, I'm a USQ alumni. I graduated in 2018, and since then, I think my path to graduating was a little bit different. I finished my degree whilst I was living and working in Jakarta. And then I came back to Australia and I guess I just started my career as a lawyer, I guess you could say. I currently work, it'd probably be wrong to describe me as a construction lawyer per se. I'm very much a commercial lawyer. I just happen to have construction clients. And I guess I haven't prepared any sort of formal, presentation today, but I just want to touch on a few things of what Julie mentioned before. When I did construction law, I did it intentionally because a lot of my background has been with the federal government. I was formerly in the Army many years ago, and then I sort of had worked in the consulting space since. So I worked with a lot of public sector tenders and large delivery projects, which is the work I continue today, just in a legal capacity. And construction law allowed me to do that. So when we talk about things like tendering, contract risk management or commercial risk management. They are all important things outside of purely construction. It was mentioned before that it was previously assumed that construction of ships was construction law, and I would tend to agree. One of my clients produces or delivers armoured vehicles for the Department of Defence. And one of the key issues, or one of the key, or a number of key terms in their contracts are things like latent defects. Now, in construction, we would refer to them as subsoil factors. And elements, say, in a very simple scenario, you might, if you're building a house, for instance, on a small scale, they might hit rock and they would charge you a variation to get through that rock to lay your slab, for example. In larger projects, it might be elements of the subsoil that require significant work or redesign to be able to support that particular, I guess, structure on that land. In delivery projects, when we talk delivery of vehicles in this instance, we talk about latent defects in terms of workmanship, design, and materials. So they are applied in the same way that we would apply latent defects in a construction sense. So there's I guess, a modern link construction law and what you'll cover in construction law subject. Things like warranties, governing law, and jurisdiction, and how you decide on a governing law in terms of your project are effectively the same way that you would cover between a construction project and any contracted I guess, scenario. Things like indemnities, warranties, insurance, liquidated damages, stop payment milestones are all factors that have similarities between construction and delivery projects in general that you need to consider. All of which are covered in construction law that you don't really cover in other subjects. I think they're very important. Another important aspect which you'll cover, I think I agree with Julie. I would suggest that you are comfortable with contract law before you do construction law, and particularly you'll cover subcontracts, and that's very important when you talk about downstream contracting from a prime, or if you're working with a big company and you're working with a head contract, understanding what those downstream contracts are, understanding how to structure those downstream contracts, understanding how to pass on risk, pass on liabilities, pass on warranties, and how you would negotiate those. And the other big one, which is frequent, and I'm lucky enough to sort of form part of the construction, mining and construction team, my firm at McCullough Robertson, is around dispute resolution. Massive in construction when you're talking claims or delay claims, for example, and passing on those claims between subcontractors and third parties, and what your contractual obligations are and what the risk is with those. And a lot of them, the majority of them, are settled out of court. But it's very important to understand the ADR process and that claims process. So I think, without taking too much of your time, I think construction law is a great subject, because these things come up not just in purely construction. These come up if you're going to work, or you have intention to work in commercial law. You will face these outside of purely construction sector. You will face these in any contracting that you do for your clients, any advice that you provide your clients. These are the exact things you need to understand that aren't necessarily covered in contract law subjects, because you're very much focusing on the fundamentals of contracts rather than these sort of more specific contractual and legal principles that are covered off in construction law. And I guess probably that's why it's covered in your sort of later part of your degree rather than early on, because it's the fundamental concepts that you need to have a grasp on before you progress to some of these more complex issues. They're not easy issues. There are still issues that the legal world battle with today. These clauses are forever changing. The drafting's forever changing. There are more modern ways and more, I guess, contemporary ways of contracting and different contractual models that certain parts of the industry prefer to others for various reasons, largely down to risk management. But I think understanding these key terms is fundamental to, I guess, being a successful lawyer and advising clients, because, as I said to we've got a graduate with us at the moment, and I said to him, it's very well and good to know the technically, I guess, the legally correct way of doing things, but then there is a commercial way of doing things that also protects you from a legal perspective. I won't go into examples, but perhaps maybe one example is a non-disclosure agreement. Yes, we all know a confidentiality deed would be legally correct, but they have problems in terms of execution. So I guess I encourage you when you're thinking about these concepts, understanding the legal consequence, but also understand how they'd be applied commercially is very important. When you get out of your law degree and you move to a firm or you move to a business, whether you're in-house or at a private firm or government for that matter. And also the $1,000 prize wasn't around in my day. So that's great news.
Well,
that's all I have. Unless anyone's got any questions, I hope that that I covered the right things.
Well, yeah, fantastic, Nick. Thank you so much. I mean, you've actually jumped to the heart of the core questions of why study construction law and also the advantages of studying construction law. So thank you very much. If I can ask a kind of related question, besides construction law, what would your advice to USQ law students be? Like, what other type of courses would be essential for a career in construction law?
Good question. I would suggest that if you wanted to get into construction, that very much anything to do with, you need to understand front end and back end to be a construction lawyer. Now, typically firms will separate front end and back end. Your bigger firms will have a construction front end, construction back end team. And by front end, I mean, it's all those non-litigation things. So establishing contracts, drafting contracts, I guess back of house legal and commercial work. So effectively tidying up your own backyard within a company, if I can put it like that. And then you have construction back end, which is your litigation and claims management. Both are fundamentally different, but both have a fundamental understanding of each other's roles. So I'd suggest anything to do with contracting, anything to do with commercial. International trade would be another one, because you're understanding there around Incoterms, which are very important in modern construction and in modern, I guess, international law, understanding what those terms are, understanding how they applied contractually, and I guess really having a fundamental understanding of contract law, and I'd say by extension, property and trust law would be another one for you to understand. That would be my advice. Julie might have something different. I haven't got the full list of subjects in front of me, but I think they're the fundamentals.
I agree, Nick. And I think that from you, but also from others in the legal profession working in a commercial field, that's often the issues you've identified are often things that some law students struggle with. It's very difficult for us to give you the real world context, particularly in some of those core courses like property and trust or equity, but the ability to commercialise on behalf of your client is one of the things that the clients will value the most. They're coming to you for your advice about that. So I think part of the reason our USQ students are so valued is that many of you come from a commercial background anyway. In the courses that we teach, even if we as academics are flat out giving you the base essential principles that Nick has mentioned, your shared conversations are often about your experiences, your real world experiences, and I think that's why the USQ graduates are sought after in terms of construction law, but also other areas of law as well.
Thank you very much. And I see that Anthony put in IR law in the chat box there.
I think you're referring to industrial relations there, absolutely. Not something I've studied formally, but I think it's worth definitely having an understanding of. Heavy union involvement in the construction industry, having an understanding that would be beneficial. Again, it's not my area. I don't really understand a lot of it, but yes, you're right. The other one too, if you're starting to talk about, I guess, construction, but going more into industry intellectual property, particularly in terms of design, trademark, patents, all those kind of things. If you had an option to study IP, that would be of, I guess, of benefit, but not so important, but certainly something you will come across your desk.
Matthew, may I just jump in too? I think
Thank you.
one of the things that Nic might be able to speak to is that he had experience both as an on-campus student and studying as an online student. And in construction law, irrespective of whether you're on campus or off, and at least now we regularly use Zoom in a way that we didn't in the past. I think one of the benefits is that you get to build networks. So construction law is often about those relationships that you have with the people that you're on the other end of the contract or within your project delivery group. And so if you have good people skills, if you're used to listening and thinking about what people say, responding respectfully, etc. In other words, treating other people as professionals, then that's a key skill that I think construction law can enable you to develop further. But also, because we have such a great cohort of alumni, they're all now sharing, that network that we're creating, which everyone who studies, goes on to study construction law at USQ join, I think is useful as well. So it does actually lead, as I'll speak to in the class, it leads to real jobs. Didn't probably in the same way for Nic because he was already working in the field that he's working in. But for many people, it's even been because of this cohort that they've been able to secure their dream job.
Yeah, I just saw a comment there from Craig. Yeah, you're right. Environmental law, again, another area of interest. You'll typically find in big firms that environmental law is actually coupled with planning law because they are very much a pre-contractual, I guess, process. And it more so, I'm not saying exclusively, you're right. And I guess by extension then, if you're talking, if you want to progress from construction to say something like mining, then native title is a big area as well. So again, all these things are absolutely relevant to you, but you'll typically find they get separated because they're so complex in their own right.
Fantastic. Thank you so much for that. I mean, just in this chat room, we have so much knowledge of different fields. It's quite amazing. What I'd like to move on now is if there, let's go ahead and open it up and have some questions. If you have any questions, go ahead and pop them in the chat box, or you can go ahead and unmute your microphone and ask. I think that Craig, I think you had a question? Okay, sorry.
I'll ask a question if that's all right.
Thank you.
Can you all hear me? Yep. Yeah, just a quick one, Nic, I guess. So my background's as an engineer and now studying law, but I guess obviously being a mature age student, it's then what's realistic in terms of a career expectation around within the construction sector, I guess, on taking a construction law type path?
Look, I think you are very well placed as an engineer and would bring a unique skill set that not a lot of lawyers have, and that is that very technical understanding. So I'm not sure what your engineering background is, but I work with a lot of engineers from mechanical to civil to electrical engineers. You will find them all in construction companies because there is obviously a bit of engineering that goes into it. So I think you would be of great benefit, particularly at a front end. Well, both back end and front end, but I could see very much a utilisation in front end because the ultimate aim here is that we avoid litigation. That's the ultimate game. So if we're good at our front end, we protect our back end. If that makes sense. And I think, but to your point about what your career expectations are, is that it would very much be at a junior, because it is a completely different perspective as a lawyer than you bring as an engineer. I'm very thankful that an engineer is studying law, because quite often the fact is that engineers don't really understand the commercial nature, and vice versa, lawyers don't understand the technical aspects. So I see actually that combo is a very good one.
Okay.
And would be well sought after in the legal world.
Yeah, it's the concept of junior, and inherent in that is pay cut.
Oh, look, I think, and I said this at an event we had at the Supreme Court. I think I might have got a few dirty looks, but I did say there is inherently a pay cut associated with starting again. It's inevitable.
Yeah. Yep.
I get it. The other option you would have is if you don't follow a non-traditional legal pathway, like similar to what I did, I suppose, and that is you move into more the consulting space and use your legal skills with your engineering background in a more commercial role, which would be a way of avoiding that drastic pay cut. Because if you went back to being a graduate, you'd have to start again. Traditional legal would be beneficial for you as well. And there are things in the Jacobs Engineering, the GHDs, those sort of places that would benefit, would be keen to speak to someone like you with both of those skills.
Yeah, I think as well. I mean, the thing that I guess I struggle to, well, not struggle with, but trying to work out in my mind is, you want to get some decent practical training before, going down a consulting path. But at the same time, there is the reality of, you've got 20 years experience in a field, and if you're starting again, my bank's not going to like me taking a pay cut to be a graduate.
Yeah, no, I get it, and that's the that's the path, and I guess that's why I took a non-traditional path. I didn't go back to graduate.
Yeah.
I just worked hard to make sure I could, make my way in a sort of another space. But there are definitely options out there for to be a little bit more hidden and non-traditional. It would just require some networking, I would say.
Can I add something on that, exactly that point, Nick? Brendan and others, this is your opportunity to get in and do that networking. So I mentioned that there will be opportunities available. For example, Kevin Pascoe, who's one of the directors of the Society of Construction Law, is giving a School of Law and Justice Research Seminar in a couple of weeks, and he's going to come along to our on-campus class, but also participate from Zoom. So, Brendan, for students like you, if you exploit that opportunity and make yourself known to people who are able to talk to you about not just the opportunities available to you, but actually the people they know that would be interested in the skill set that you have, then that's your opportunity. I think, Nick, I'd be interested in your view about this. My understanding, or my sense is that in finance, for example, it's now become perhaps less attractive for graduates to go into graduate roles, because the opportunities are often in the more niche jobs, in firms that will give you real work from the very first day, drawing upon the interest and the expertise that you might bring, particularly if you are older. But law hasn't yet done that. So law hasn't yet really thought about the fact that from law degrees, particularly from JDs, there are people who aren't straight from school, who've done a law degree, who are then looking for their first job in a workplace. And so you might think yourself to be non-traditional, but in terms of USQ and our graduates, you're actually probably typical of our graduates. And the more we can build our networks, and you can build your networks with the various professions that recruit from law schools, the greater opportunities that there are to be able to avoid that dreaded pay cut. Students have done that. Students from our law school, students from construction law have managed to do that. But I agree with Nick. I think the key is the networking that you can do while you are or prior to your graduation.
That was a very good question, Brendan. And I think that we all have that, all the people who are kind of thinking about changing careers, we all have that same concern. So thanks so much for that question. Was that answered fully? Thank you.
Yeah, it was. Yeah, thank you.
Great, great. So I just saw a question from Katrina pop up in the chat box. Katrina, would you like to ask that, or do you want me to go ahead and read it out?
Sure.
Yeah, I think
Sure. So I just have a question. I was wondering whether, can you hear me?
Yeah.
Okay. So my question is, in a commercial setting and construction, being a construction lawyer, would you say that mediation skills would be highly sought as the back end because most matters will settle outside of litigation?
In short, yes. If you're going to do back end, it's all about the negotiation. A lot of other things that go into back end litigation, like discovery and I guess all the necessary evils that are attached to that. But yeah, I think if you could have some mediation skills, and that is negotiating and those people skills attached to that, all those soft skills, that definitely wouldn't go astray. There are a lot of mediations associated with back-end construction, and they're typically dictated by contract. In that there will be a mediation clause within your contract or a dispute resolution clause, which will involve mediation, to say litigation. But yes, absolutely, it's all those soft skills that would go along with a mediation course that would be of benefit.
Okay, perfect. Thank you.
Yeah, I think that was a good question, especially because that USQ also has a accredited mediator course that I've seen that honors and JD students can take.
Going back to your point, Brendan, if you can do a meeting, you won't have to grab it. Good ones are paid quite a lot. Ex-High Court judges, for example.
I think I know exactly which one you're talking about, but the WA government decided they didn't want to pay that.
In the past, also, it's a way in which you could have a very nice life internationally, if that was what you're after. But unfortunately, one of our Queen's Counsel, who's ordinarily based between Brisbane and London, is currently stuck in London and can't get back to Brisbane. So COVID's changed, I guess, some of that international movement.
Yeah, thanks, Katrina, for that question. That was a very good one. Does anyone else have any other questions?
Can I make an observation, Matthew, in relation to Ray's post about 90% of disputes being settled outside the court? In construction law, arbitration is very important as well. And I think that's one of the things that you don't necessarily get the exposure to in other courses that you do. And we don't spend a lot of time on arbitration, but it is actually an essential way in which you resolve disputes if you get to that point in construction law as well. So it's a practical way in which you can come to understand arbitration. Similarly, with the Jessup mooters, the USQ Jessup moots, the Jessup mooting team started because some of the students in next year said, look, we'd actually like to do one of these moot competitions. Could we get something going? And that was because they'd taken part in a construction law moot during their time as construction law students. So arbitration is important as well if you have an interest in that.
Excellent. Thank you very much, Julie, because that's exactly the question I was going to lead into because of the Ray's question regarding ADR. And then also I saw that Ray popped in another comment. He would like to know the comments on the role of the building certifier, particularly in those buildings in Sydney. So either Julie or Nick, could you comment on that?
Julie, I'm going to defer to you. This is not my area. Sorry.
I thought you might need, that's fine. It's not really mine either, but to the extent that I'm assuming, Ray, that you might be talking about the flammable cladding or the other issues to do, I'm trying to think of where it was. It was at Homebush, wasn't it? The buildings
I
that,
think it was the cracks in the building and the latent
Yes.
defect.
yes, that's right. So we talk about that and some of the case law in about halfway through the semester. And we talked to an extent about building certifiers. I think I put in the Law 3473 forum that, for example, one of the students last year wrote a fantastic paper about building certifiers because he came from a background where it was a particular issue. I think it is a particular issue in Queensland at the moment. The government over about 30 years, starting with the SCUR report, probably more than 30 years ago, has attempted to put in place a mechanism that works, but at the moment it's not working as well as it might. And there are these big problems that people in construction know about. So the flammable cladding, for example, is throughout buildings in Queensland, and we haven't yet worked out the best way in which to resolve that. We haven't worked out the best way in which we can make sure that if we are building something, that the appropriate mechanisms to ensure it's going to be viable into the longer term are in place, whilst at the same time making sure that we don't make it too prohibitively expensive for people to certify. So do we have private certifiers who have to meet government standards? Do we have government certifiers? We've tried just about everything in Queensland now. So I look forward to talking to you about that, Ray, down the track a little. Maybe that's something you could research and learn.
Yes, so I think for the people who aren't familiar with Ray, in the forum, he said that he has, I can't remember, 20 or 30 years of engineering experience. And we actually took a contract course together. So he's very interested in how contract as well relates to construction law.
And actually, sorry, I did just have another thought. Ray, one of the two key texts that we use is written by Ian Bailey, who's the Senior Counsel from Sydney. He's had a lot of involvement in the mascot towers and other issues, both on behalf of the construction industry, but also government listens very closely to what Professor Bailey has to say. And he's quite involved with our construction law course. So if you have a particular interest, I'm sure that we could get him along to talk about it. So please let me know what it is that you'd most like to discuss, and we'll work that out with Professor Bailey.
It looks like Ray is getting a bit of an echo, so I'll just repeat that maybe he can hear a bit better from my microphone, but Julie was saying that Ian Bailey, who's one of the authors of the textbook, is very familiar in that area, and perhaps we can invite him to be a speaker in in a session in class. So Raymond, were you able to hear that? Okay, good. Yeah, it looks like it worked out. All right. Are there any other questions? If it's possible, what I'd like to do is, for the participants in the seminar, would it be possible for you guys to pop in the chat box what field you guys are in? Are you law students or are you engineering students? What kind of background do you have? If you could just pop that in the chat so we can get an idea of what the participants are coming from. So I think I recognize Dennis's name from the forum, that he is an engineering, I think, and studying law. Great. So it looks like most of the people attending are law students, and also many of them have backgrounds in other fields. So if I may ask my own question, Julie, so you're speaking about arbitration. How much detail does the course go into regarding arbitrations?
We look at some of the case law, Matthew, and we talk about, actually we also look at the statutes and the international commitments Australia has made to ensure that we have commercial arbitration in place. But importantly, I think one of the key points, maybe Nic even remembers this, one of the key points is that jurisdictions fight for arbitration, because if you have arbitration, if you're an attractive forum for arbitration, then it brings a lot of revenue to your jurisdiction. So there are key venues where people choose to arbitrate, either because they like the law that governs that jurisdiction, or they know that arbitration is taken seriously, is enforceable in the relevant ways, and that they will be able to get their choice of arbitrator to that, to hear an arbitration in that venue. So Australia's actually done an awful lot of work about this. When I worked for the Court of Appeal judges in the early 90s, the Queensland legislation was being put in place, and people like Justice Davies, who'd been Solicitor General and one of the leading commercial silks. In fact, all of the Court of Appeal judges at that stage had really come from a leading commercial silk background. For them, that was one of the key things that we needed to put in place in Queensland, so that it would build not just our economy, but it actually builds the profession as well, because it's an important skill and an important skill set for legal practitioners to have. So, Matthew, we talk about arbitration at various stages, including because, as Nic said, if your dispute resolution clauses are actually very important when you're at the front end, when you're drafting your contract. It's one of the things that you think about really in terms of construction design. If we have a problem, how do we sort this out down the track? But we also at the back end talk about arbitration, ideally how to avoid having to expend that amount of money and that amount of time, and to delay your project potentially via arbitration. But we talk about it probably across 3 weeks in various respects at the back end. Did you want to add something? Sorry.
I think if I can add there, Julie, sorry, I agree. Arbitration is horrendously expensive. So hence why it is normally outside of a court process is a last resort. It is horrendously expensive. If you want to look up on it, look at things like the New York or the Singapore Convention. Singapore have been quite proactive in the arbitration space. And I was going to say something else, but it's just slipped my mind.
I think
sorry, it's literally just slipped my mind. I had an absolute blank. Sorry, Julie.
You might have been going to say, Nic, that often arbitration is chosen because people want to keep their dealings secret. So
absolutely. Sorry. Yes, Julie, you're right. That was one of my points. You're right. And that is an advantage to arbitration as opposed to a formal court process. The other modern, I guess, and to go back a little bit on dispute resolution, one of the more modern approaches to avoiding litigation are these things called dispute resolution boards. Now, they're very new, I suppose, to modern construction contracts, but effectively what happens is that both parties will appoint a person to act on their behalf in a dispute resolution board, and then each of those appointed parties will then jointly appoint a chair of a dispute resolution board. and that will sit over the top of a project or a group of projects or a joint venture, whatever the case may be. And effectively, the two entities will act on their advice when a dispute arises. So that's something to look up to. Maybe a point for research in construction law is the use of dispute resolution boards and how effective they are at resolving disputes as a more modern example of dispute resolution. But arbitration is very expensive. It can take a long time to bind a result. That there can be binding, there can be non-binding. So I guess they're very complex. It's probably a whole subject on its own.
Yes, thank you very much. I think if there's anyone out there who didn't understand my joke before, I think that you were referring to former Justice McHugh, who was the arbitrator for the mineralogy claim from Clive Palmer, which the WA just passed legislation to invalidate some billions of dollars of arbitral awards. So that was my joke, if no one caught that inside joke.
Matthew, just to show that there is a huge benefit to coming along to this seminar today, I am currently setting the assessment for this semester, and some of you might like to have a look at mineralogy a bit. Well, you will all be having a look at mineralogy, the mineralogy decision a little bit closer, because I think that just as when you learn up with me, if you have some familiarity with the importance of trust law by Clive Palmer and his commercial litigation difficulties, then a case like mineralogy actually makes you think very carefully about what's at stake in terms of arbitration. That's not actually a question. You'll be looking at it today.
Yes, Anthony just popped in the chat that we looked at mineralogy and WA and constitutional law. And so the biggest thing I think Nick was saying is, if it's if the awards are so I think the key point is the judicial review of arbitral awards. Is that a possibility or not, right? So I'm waiting for Anthony to jump in there and say yes or no. He says no. Okay, so this will be a great point of discussion in the class.
It will. Well, that's not actually the question I'm going to ask you. Don't worry, I'm well aware of Anthony Gray's paper about the mineralogy case, and he and I had a chat about it a couple of months ago. So I think it's good actually to build upon understandings and to have to pivot your thinking in a different context.
Right. Okay, well, we have.
Can I just add, sorry, Matthew, I was just going to add, purely arbitration goes and DRBs both go also to that point that Brendan raised before. So if you've got that breadth of expertise, then you'll be the person who down the track will be well placed to be exploit that via work with dispute resolution board, arbitration, dispute resolution, a range of different roles in construction law that require something beyond or a depth of understanding that lawyers alone, engineers alone don't.
Thank you very much for that, Julie. Well, we have a few minutes left. Are there any last questions anyone would like to ask?
Can I ask Nick a question? Would you mind, Matthew? Nick, about 2 years ago, I went to a Society of Construction Law event, which was aimed at law students, construction law students, and it was telling them the things they really needed to know so that they could secure the jobs that they needed in the workplace. Essentially, it was employers saying, this is what we look for in a law graduate. I wonder if you might speak to that, because it carries so much more weight if it comes from a practitioner and it comes from someone who's actually been through that process themselves.
It's a good question, Julie, and I think I'll caveat my response with I don't think there's a one size fits all, and I think generally speaking, if you have a good knowledge of contract law, you have a good understanding. Sorry, my connection might be breaking up there again. If you have a good understanding of construction law, you have a good understanding of contract law. I think if you have a commercial, pragmatic approach to things, and I think you are you have some good interpersonal soft skills. I think they cannot hurt when it comes time to getting a job in construction law. What I will say though is that network is absolutely key. Very much from my perspective, I mean, I can't teach attitude and enthusiasm, but I can teach legal technical skills. We can work on them, but I think my personal view, it's a lot of those soft skills that are so very important when it comes to construction law. It's I find it a mix between technical mastery and that sort of those pragmatic soft skills, interpersonal skills, EQ, if you like, that are really important. Because what happens is you can have lawyers who have, straight sevens across their degree, but they can't talk to a client. I can't put them in front of a client. And I say that respectfully because there is a place for those people, particularly in the front end roles. But yeah, I think it's all about having a good balance, having some life experience behind you, having a bit of a thick skin, particularly for back end, but very much that commercial, pragmatic approach to things is very important and what clients value most. Across the legal fraternity, it's commonly known that the first person to bugger up a deal is a lawyer. And we take the approach in our firm that you want to be removing obstacles, not placing them up. We're dealing with our clients and working with our clients.
Thank you, Nick. At that Society of Construction Law event I was at, one of the speakers was from the Inland Rail project.
Oh, yeah.
And we're going to talk about it in week 1. They have a big office in Brisbane, and they look for people. Their website says that they're looking for people all the time. But he says that the one thing that he would focus on, or that he would think is more important than anything else, is fit. And that's the thing often that people underestimate. If you've worked in a workplace before, that emotional quotient, that emotional intelligence helps you to work out how you will fit, what's needed of you, what degree of initiative, what degree of, being for a bit more instruction, just getting in and making sure that the team works as a team. That sort of thing, he said, is the key thing that makes or breaks not just the team, but often a project. And so for him, it's really important. Oh, and I should say he came from a background in one of the large commercial firms in Brisbane.
Yep, and if you're going to go down a law firm, I mean, I'm biased a little bit, but McCullough Robertson has a great culture. But that's, you fight very hard to maintain that culture, and it is hard. It's one of the best firms I've worked at, and I've worked at Department of Defence, I've worked at KPMG for a number of years, I worked with Big Four Consultancy, other Big Four consultancy firms for going down a traditional legal pathway. And culture is huge, and a big part of that is cultural fit. And again, that's why I say I can teach someone the technical skills, but I can't necessarily teach them their attitude and enthusiasm, and that's really important. And I think that's important to portray, particularly in the interview. And that's one of the hardest things about getting a job. If you can just get to the interview, you're good. It's that paperboard initially, and that's why life experience, I think, is important. I'd much rather take someone with life experience than someone who's not had that life experience, just because I've sort of been there. I've worked with those people, and I much prefer someone with a good EQ with a good balance of sort of academia.
Yes, thank you very much for that, Nick and Julie. All right. Are there any more? Are there any last questions? If not, I'd like to wrap up by giving a very special thanks to Nic Gould and Julie Copley. And I thank each of you, the participants in this seminar, for joining. And it was my hope that you learned something a bit new about our field of construction law, our meaning our students, hopefully, or future students in the course. And oh, so there was a question from Ray. Yes, so this is being recorded, so the video will be uploaded. I don't know the location. I will coordinate with USQ Law Society because I think they have a place to put the videos. So thank you everyone again for joining. And if there are any other comments, go ahead and pop them in the chat box.
Or email. I'm happy for people to email me. Thank you, Matthew.
Yes, and thank you, Julie. Julie is so responsive on email. That's really appreciated. And thank you very much, Nic. I understand you're in some big negotiations or something secret like that. So thank you very much for taking time out of your busy day for the seminar.
Thank you. I'd much rather be here than in there, so that's good. The excuse. Thank you all. Good luck with your course. Thank you, and you're in good hands with Julie. Thank you all very much, and at some stage.
Thanks all very much, and have a great day.